also to introduce the bench. I am presiding with the Honorable and also is the Honorable Justice Joaquin Dongo, the Honorable Mr. Justice Isaac Lenaura, and the Honorable Mr. Justice for the applicants and the petitioners, because we are hearing this matter together. We are hearing both the application and the petition of appeal together. We will determine whether to uphold or not the objection in one comprehensive judgment. We do not have the luxury of time to hear the application and then go to the petition. We have decided to subsume both the notice of motion and the petition together. So in your arguments, you will combine both, and we are giving each party 20 minutes. 20 minutes for the petitioners and for the first and second respondents who are together, 20 minutes, and for the third and fourth respondents who are together, 20 minutes to combine your arguments on the two matters. Is that understood?
That is understood, Madam CJ.
Yes.
Yes.
So
on our part, Madam CJ, that is acceptable.
Thank you very much for your indulgence. Then I'll pass it on to the petitioner. Please take it on.
Madam CJ, Madam DCJ, and members of the Supreme Court, on behalf of the petitioner, Mr. Paul Nyamodi will present our arguments. Mr. Paul Nyamodi.
Good morning, Chief Justice and members of the bench. As I have been introduced by learned Senior Counsel, I am Paul Nyamodi, and I appear together with Mr. Kilukumi Senior Counsel and Mr. Mansour for the petitioner. And these are the submissions, or before getting into the submissions that we have in respect of this petition of appeal, I just want to quickly put on record the filings by the petitioner. The petitioner has filed a petition of appeal dated the 31st of July this year, together with a record of appeal that runs into 31 volumes. The petitioner has filed a statement of rejoinder in response to the petition of appeal, dated and filed on the 18th of August this year. The petitioner has filed grounds of objection to the notice of motion by the first and second respondents, and those grounds of objection dated the 18th of August this year. And lastly, the petitioner has filed written submissions dated the 18th of August this year in support of the petition and in opposition to the first and second respondents' application. Chief Justice and members of the court, I wish to rely on the written submissions that we have filed, and they are fairly comprehensive in support of the petition of appeal and in opposition to the first and second respondents' notice of motion. And I wish to quickly just make the following highlights. Chief Justice and members of the court, this appeal emanates from a decision of the Court of Appeal, where the Court of Appeal used non-existent rules of procedure to determine the appeal for it. The fact that the Court of Appeal used non-existent rules of procedure in arriving at its decision to strike out the petitioner's appeal is not disputed by the respondents. There is, however, contestation as to whether this appeal, which is premised on the said uncontested facts, is one involving a matter of constitutional interpretation and application, and therefore falling within this court's jurisdiction under Article 143, Subarticle 4A of the Constitution. This issue arises from the objection to this court's jurisdiction taken by the respondents. The respondents have framed their jurisdictional challenges as follows. The first and second respondent have anchored their jurisdictional challenge around the premise that the petition of appeal is incompetent, as no leave as required by Article 163(4)(b) of the Constitution was sought and obtained prior to the filing of this petition of appeal. The third and fourth respondents support that position, and in addition, at paragraph 26 of their response, they misrepresent the tenor of this appeal as being one that merely challenges the Court of Appeal's interpretation of Rule 6 of the Court of Appeal's Election Petitions Rules 2017. It is submitted on behalf of the petitioner that because the facts upon which this appeal is premised are not challenged, the resolution by this Honorable Court of the respondent's jurisdictional challenge will determine not only the appeal, but it will also determine the first and second respondent's notice of motion dated the 11th of August 2023. I will return later on, Chief Justice and members of the court, to this point as to how the resolution of the jurisdictional issue in this matter determines not just the petition of the appeal, but the notice of motion. Though the facts upon which this appeal is premised are not challenged, we submit that the resolution of the jurisdictional challenge must commence with a consideration of the facts of this appeal, notwithstanding the fact that these facts are not challenged by the respondent. We submit that it is not disputed by the respondents that the Court of Appeal relied on non-existent rules of procedure in arriving at its decision, contained in its ruling delivered on the 24th of July 2023 to strike out the petitioner's appeal before the Court of Appeal. Members of the court, that ruling is found in Volume 1 of the Record of Appeal at pages 3 to 28. The decision, or the part of the decision that is appealed against, so that the appeal arises from, is found at paragraph 42. Paragraph 42 of the decision is on page 22 and 23 of the record, and you will clearly find in paragraph 42 and paragraph 48 of the decision that the Court of Appeal clearly relies on rules that are non-existent. And I will demonstrate shortly why we submit and why it is the position of the petitioner in this matter that the rules of procedure relied upon by the Court of Appeal were non-existent. The Court of Appeal's finding on the form and content of the notice of appeal is found at paragraph 31 of its ruling. That, members of the court, is found on page 17 of volume 1, and in paragraph 31 of the ruling of the Court of Appeal, the Court of Appeal sets out extensively what it states, or what it relies on as Rule 6.3 of its rules of procedure, and it sets out Rule 6.3. Rule 6.3, according to the Court of Appeal, has paragraphs A, B, C, D, E, and F. It is clearly stated out in the ruling, and I will not take the court's time to go through it. But I will demonstrate in a moment why that provision that the Court of Appeal used to rely on, or relied on to arrive at their decision, is non-existent. The finding, and I cannot emphasize this sufficiently, the finding by the Court of Appeal that the notice of appeal filed by the petitioner before you, the appellant before it, was incompetent, was based on non-existent rules of procedure. Chief Justice and members of the court, the rules that the Court of Appeal, or the provisions, it is difficult even to call them rules, the provisions that the Court of Appeal relied on to arrive at their decision are set out, or are to be found in volume 30 of the Record of Appeal, from pages 4,272 to pages 4,285. The particular Rule 6 that the Court of Appeal relied on is to be found at page 4275, and there is one sentence on the top of page 4276. In the petition of appeal, we have set out extensively the manner in which this particular document was circulated. In the record of appeal, in volume 30 of the record of appeal, at page 4272, is a letter from the Judicial Committee on Election Preparedness that circulated these draft rules for discussion. Chief Justice, members of the court, that you will note that on page 4273, the space for legal notice number at the top right-hand corner of that page is blank. These rules never acquired a legal notice number. The correct rules of procedure that the Court of Appeal should have used are to be found on pages 4286 to 4298 of volume 30 of the record of appeal. Members of the court, Chief Justice, you will note that at the top right-hand corner of page at the top left-hand corner of page 4286, the Appellate Jurisdiction Act, the Court of Appeal Election Petition Rules 2017, and these ones clearly have legal notice number 114 of 2017 marked on the top of these rules. We submit that these are the correct rules of procedure. These rules of procedure do not provide the same provisions as Rule 6 that the Court of Appeal used to determine the appeal before it. And we submit further that this Honorable Court, in your decision in Anwar Loitip at paragraph 67, confirmed that these are the correct rules of procedure, and these were the rules of procedure in respect of the Court of Appeal that this court relied on in paragraph 67 of its decision. This issue of the manner in which the Court of Appeal used the wrong rules of procedure has been dealt with extensively in paragraph 19 of the petitioner's written submissions. And for emphasis, I wish to adopt paragraph 19 and urge members of the court to look at that paragraph as we demonstrate there clearly why we believe the Court of Appeal used the wrong rules of procedure. Just to emphasize, members of the court, why we submit that the Court of Appeal used the wrong rules of procedure, I wish to take a brief moment and just highlight various findings by the Court of Appeal in respect of these rules. In volume 1, at page 12, line 19 and 20, the Court of Appeal makes this finding or states as follows in respect of the rules of procedure. It states, we note that the rules have been revised and the provisions now cited appear as Rule 17 in the Court of Appeal Rules of Procedure. Rule 17 in the non-existent rules is the same as Rule 19 in the proper rules. According to the Court of Appeal, the rules had been amended and Rule 19 has now become Rule 17. It is our very respectful submission that the Court of Appeal makes a fundamental error here, because they say that the rules are amended, but they do not then demonstrate or do not show the amending instrument. It is merely a statement by the Court of Appeal that the rules are amended. Again, at the top of page 14, line 1 and 2, the reference to Rule 17, the non-existent Rule 17, it is Rule 19, and I will demonstrate how even the respondents in this matter have asserted or have confirmed that that rule is Rule 19 and not Rule 17. Again, in paragraph, in volume 1 at page 9, in paragraph 14, again in reference to Rule 19, the Court of Appeal in line 18 at the bottom of the page, when referring to Rule 19s of the proper rules, then refer or put in brackets the word seek. That reference again to Rule 19, seek, is found on line 5 of page 10, and the Court of Appeal is asserting by placing the word seek after Rule 19 and Rule 19.2 that the reference to Rule 19 is wrong. Again, I submit this clearly demonstrates the fact that the Court of Appeal were using the non-existent rules of procedure. Again, I have submitted that the respondents in their response to this petition of appeal have relied on Rule 19 in opposition or in support of a decision by the Court of Appeal where the wrong rule of procedure is used. The respondents have used the right rule of procedure. The first and second respondents' response at paragraph 23. The third and fourth respondents' response at paragraph 12. When referring to this point, they do not use Rule 17 because it is apparent even to them, I submit, that Rule 17 is from the wrong rules. They use Rule 19. The notice of appeal that was the subject of consideration by the Court of Appeal is to be found on page 4299 in volume 30 of the Record of Appeal. Its receipt for payment is found at Rule 40 in the same volume, volume 30, at page 4301. And it is our very respectful submission that when Chief Justice and members of this court retire to consider your ruling in this matter, you will find that that notice of appeal is compliant with Rule 6 in legal notice number 114 of 2013, the Court of Appeal Election Petition Rules 2017. If the Court of Appeal had relied on the right rules of procedure, then they would have arrived at a different decision. Members of the court, the issue of jurisdiction is dealt with, and I wish to move on to the issue of jurisdiction now. And the issue of jurisdiction is dealt with comprehensively in paragraphs 9 to 43 of the petitioner's written submissions. I wish to make the following highlights. It is submitted that this court has jurisdiction, to hear and determine this appeal for the following reasons. First, the reliance by the Court of Appeal on non-existent rules of procedure violated the petitioner's right to a fair hearing guaranteed by Article 50, Sub-Article 1 in the following way. Article 50, Sub-Article 1 guarantees every person the right to have a dispute that can be resolved by the application of law, resolved in a fair manner. I wish to emphasize the resolution or resolved by the application of law. That provision of Article 50, Sub-Article 1 creates a duty on the dispute resolver. And in this instance, that dispute resolver was the Court of Appeal. And in resolving the dispute that was resolvable by the application of law that was brought before it by the petitioner before you this morning, the Court of Appeal did not use the applicable law. And the applicable law and the correct law in that instance is at legal notice number 114 of 2017. Having not used that legal notice or having used non-existent rules of procedure, in and of itself, we submit that that is a violation of the applicant's or the petitioner's right to a fair hearing. Further, we submit that the Court of Appeal's reliance on non-existent rules of procedure to determine the dispute that was before it amounts to a fundamental jurisdictional error which is amenable to this court's jurisdiction under Article 163, 4A of the Constitution. Chief Justice and members of the court, this court has had ample opportunity to consider this jurisdiction or its jurisdiction under Article 163, 4A of the Constitution, and there are several decisions, many of which we have relied on in our submissions. But at this juncture, I wish to assert that it is our belief as the team on record for the petitioner that the decision of this court in the celebrated decision of this court in Lawrence Ndutu is good law. It confirms that for an issue to be an issue that falls within this court's jurisdiction under Article 163, 4A, it must have been an issue of constitutional interpretation and application that has been litigated vertically upwards through the system of courts. It was an issue in the High Court. It was an issue in the Court of Appeal. But we also submit that this court has found that there is an exception to this general rule set out in this court's decision in Lawrence Ndutu. And this exception is to be found in this court's decision in the Geoffrey Asanyo matter. Chief Justice and members of the court, we have submitted on these two decisions extensively in paragraphs 17 and 21 of our written submissions. And I wish to adopt, for the purposes of emphasis, those two paragraphs. Maybe just to submit quickly, why do we believe that this matter falls into the Asanyo exception to the general rule set out in this court's decision in Lawrence Ndutu? Firstly, and with tremendous respect to the Court of Appeal, we believe that the jurisdictional error by the Court of Appeal in relying on non-existent rules of procedure to determine a dispute before it is of such an abominable nature so as to bring the administration of justice into disrepute. Secondly, any court to which such an abomination is brought, any court to which to whose attention such an abomination is brought has a duty to remedy the abomination. And lastly, to decline jurisdiction in the circumstances of this matter would be a dereliction of constitutional duty. The Court of Appeal made a mistake. They relied on non-existent rules of procedure. This fact alone, we submit, brings this matter into the Asanyo exception to the general rule set out in Lawrence Ndutu. The appeal we submit clearly involves matters of constitutional interpretation and application, bringing it squarely within this court's jurisdiction under Article 163(4)(a) of the Constitution. I had made the submission earlier on that the resolution of the jurisdictional issue, which we believe we have addressed sufficiently in our submissions, resolves not just the appeal, but the notice of motion and the objections taken by the respondents as to this court's jurisdiction. And we say so because we submit that in determining the jurisdictional issue in favor of the petitioners, which we very much hope this court will do, the court will of necessity, amongst other issues, find that the Court of Appeal used non-existent rules of procedure to strike that once this finding is made, we submit that once this finding is made, the appeal should be allowed ex debito justitia as a matter of right. It is not challenged. It is of such an extreme nature that really, once that is resolved, that then resolves all the disputes before this court. Failing to remedy this grave jurisdictional error by the Court of Appeal would bring, and again I emphasize this again, the whole system of administration of justice into disrepute. The respondents have focused, I submit, their responses to the petition solely on the issue of jurisdiction. And we believe that in our written submissions and in the highlights that I have made this morning, we have adequately responded to the issue of jurisdiction. I wish to take a few moments just to make brief submissions on the remedies that the petitioner seeks before the court this morning. The first remedy is the remittance back of this or of the appeal to the Court of Appeal with the direction that it should be heard by a bench other than the three learned justices of the Court of Appeal who heard and determined the matter when it was before the Court of Appeal the first time round. But in making that direction, I wish to point out to this honorable court that this is an election matter. It is an election matter that is governed by certain strict constitutional timelines. We all remember the matter in the last election season of Martha Karua, which I had the privilege of litigating in this court twice, and the unfortunate occurrences that happened both in the High Court and in the Court of Appeal when the matter was remitted back very near to the end of the constitutional timeline. Bearing that in mind, and bearing the directions that this court made in the Martha Karua appeal, if this court is minded to remit this matter back to the Court of Appeal for determination, it is our kind and humble request that it be done with certain strict directions as to the manner in which the Court of Appeal should hear and determine that matter before the end of its constitutional timeline, which runs out on 1st of October this year. In the petition of appeal, there is an alternative prayer. And that alternative prayer, members of the court, is to be found at page 40.
Council Nyamodi.
Yes, Your Ladyship.
From the screen, your time is up. You're going on as if everything is okay. You're not even asking for extension of time.
Sorry, Your Ladyship, I was using my screen.
The guiding screen is the court screen. It showed a while back, but you've run out of time, and you're just going on as though it was okay. Yet we are talking about time here, aren't we?
My apologies for that. My apologies for that, DCJ. May I ask for just 2 minutes to conclude?
Judge President.
2 minutes, please. You conclude. We must observe time because you have written submissions, and we are aware of the orders you sought.
Most obliged. Just to conclude, the alternative prayer is at page 40, prayer 3. If this court is minded to determine the dispute between the parties, as it is entitled to do between the Court of Appeal, then all the material which the court requires to determine that this dispute exists in the record of appeal. We request that costs be awarded to the petitioner in this matter against the respondents. And we say so because it is our submission, and it is clear from the record of appeal that it is the first, second, third, and fourth respondents who led the Court of Appeal down the garden path in reliance of non-existent rules of procedure. And for that reason, allied to the fact that this is an election matter, costs should be awarded to the petitioner in this matter. Lastly, we request that in determining this matter, this court invokes Rule 28.2 of your rules of procedure that provides that the court may issue a decision while reserving the reasons for such a decision to a later date. We believe that matters like this is the reason why that rule was created. We humbly request that if the court can give us the decision as soon as possible, the reasons can then follow. We submit that there will be no prejudice occasioned to anybody because this is the last court of judicial authority. There is no appeal from the decision of this court. I am most obliged. I am grateful for the indulgence. That is the end of the submission on behalf of the highlight on behalf of the petitioner, unless, of course, there is any questions that the members of the court would wish me to respond to.
Thank you very much. We move on to the respondents, unless the bench wishes to ask questions at this stage.
CJ, let's reserve questions to the end of the...
Not at this stage, sorry. Yes, Judge Denola, not at this stage, CJ.
Thank you very much. We can move on to the response by the first and second respondents. You have your 20 minutes.
Your Ladyship, I will take 10 minutes. I'll share my time with the learned friend Omwanza Ombati. I will take 10 minutes. He will take 10 minutes. I will move straight to what we have filed, Your Ladyship. We have filed a joint response to the petition dated 11th August 2023. We have filed an application to strike out dated 11th August 2023, which I shall immediately argue. We also filed submissions dated 21st August 2023 in support of the striking out motion and in opposition to the appeal. Madam Chief Justice, Deputy Chief Justice, and Your Ladyship, we also filed a list and band of authorities dated 4th September 2023. In the motion that we have filed before this court, we contend and argue that this court has no jurisdiction to entertain the current petition and appeal before you on account of jurisdiction and on the interpretation of Articles 163A, which is the article that the appellants have used to file the petition of appeal that appears in Volume 1. Madam Chief Justice and your lordships and ladyship, the appeal, the ground of appeal as set out appears at paragraph 27, and that the contention here is that there was no right, or the right to a fair hearing guaranteed under Article 51 of the Constitution was violated by the Court of Appeal, and in draft the appellants proceed to state that that right was denied because the Court of Appeal relied on the draft Court of Appeal election rules 2017. We will argue that on the basis of the Munya case that we have cited, Munya 1 and Munya 2 specifically, this court will only assume jurisdiction to hear a matter where, one, there is involved the question of the interpretation of the Constitution and or application of the Constitution. No argument and no ground, your ladyship and my lords, sets out any violation or any contention that the parties were either denied a hearing at the Court of Appeal and or there was a matter that flows directly on the question of interpretation and application entertained by the High Court and the Court of Appeal, and which finds itself before this court. My lords and your ladyship, it is clear that there being no constitutional question for interpretation to invite to interpret, this court cannot entertain the appeal before you. We have cited a number of cases in our list, and I just want to go straight to decisions of this court because these points are tried. Zebedo, Opore, and IBC, which you decided, my lords and your ladyship, an appeal flowing to this court where the appellant invoked Article 163 4A, and the parties then challenging finding of the Court of Appeal on the legalities and malpractices. This court struck out that appeal in a unanimous judgment delivered on 5th September 2018 on the basis that there was no flow of interpretation or application by the High Court and the Court of Appeal. In fact, the appellants had listed violations of Articles 81 and 86 in addition to Article 50, where they had been heard by the court, and the court declined to entertain the appeal before this court. My lords and your ladyship, I just want to refer the court to two things. My learned friend has contended that this appeal was determined on the basis notice number 114 of 2017, which the court relied. I want to refer to the judgment of the court that appears from pages 3 to 28. The penultimate decision of this court, my lords, is found at paragraph 50, paragraph 50, your ladyship, and not paragraph 30. Paragraph 50, your ladyship, the court struck out the appeal.
There is interruption. There is interruption. Who has not muted?
It's taking my time. Taking the time.
Is a guest called Kuso. If Kuso can switch off the microphone.
Proceed, Senior Counsel.
My Lord, I think I've lost almost 4 seconds.
It's okay, you'll be compensated.
Yes, the penultimate finding of the court, my lords and your leaderships, is found at paragraph 50, which appears at page 27 of the record. And at paragraph 50, the Court of Appeal found that accordingly, this court upholds the response to any objection. Without holding, it is clear that the record of appeal herein be struck out on account of offending Rule 6 and 8 of the Court of Appeal Rules 2017. Accordingly, we strike out the appeal and award costs. Your Lordship and my lords, the problem before you is two-pronged. Number one, in the record of appeal filed before the court, the initial record of appeal, the notice of appeal that is filed and that appears at page 1563 is not compliant with Rule 2 and 6.1, not 6.3, 6.1 of the rules of this court, legal notice number 114. The Appellate Court of Appeal Election Petition Rules 2017, legal notice 114. Because the notice of appeal, my lords and your ladyship, was lodged in the High Court as opposed to the Court of Appeal. The record of appeal as filed was therefore non-compliant with Rule 6.1, but it did not stop there, my lords and your ladyship. Rule 8 of the Court of Appeal Rules 2017, is number 114, my lords and your ladyship, sets out a requirement that the appeal of the record of the notice of appeal specifies in the one should be filed in the registry, which is the Court of Appeal registry. This was filed in the High Court registry, but 2 must specify what parts of the judgment are appealed against and must therefore be compliant with Section 85A of the Elections Act, which is enacted pursuant to Article 87 of the Constitution. So there was no record of appeal as required by Rule 8. And that is why at paragraph 50, the Court of Appeal struck out the record for being non-compliant with Rule 6.1 and Rule 8 of legal notice number 114 of 2017. My lords, in the Musa Sirma decision that this Court of Appeal, this court dealt with, Musa Sirma is almost on all fours with the question. In Musa Sirma, the record of the notice of appeal was lodged in the High Court, and this court had an opportunity to deal with an appeal such as the one before you that sought to validate a notice of appeal filed in the High Court. The court, in interpreting Article 159(2)(d) of the Constitution and whether the court should have extended time, relied on the Nicholas Salat case and cemented the legal question, my lords, that a notice of appeal is a primary document. And my lord, we submit, and that is why this appeal must fail, that there was no proper notice of appeal on record. And the Court of Appeal, the hands of the Court of Appeal were tied. It had no option but to strike out the appeal for non-compliance with Rule 6 and 8 because there was none record. Learned friend Mr. Nyamodi has submitted, my lords and your ladyships, that a document was later introduced in court in the form of a compliant notice of appeal dated the 10th of March 2023. And he referred to page 4193 of the record. That notice of appeal, my lords and your ladyship, was introduced through a replying affidavit dated 19th May and that appears at page 4189 to pages 4191. No amount of argument of any form, therefore, your ladyship,s and my lords, can cure the fact that the record as initially filed on the 3rd of March, 9th of March 2023 did not have a compliant notice of appeal. And my lord, if you look at the ruling of the Court of Appeal, the Court of Appeal did not deal with what my learned friend has referred to as draft rules and Rule 17 and or 19. Rule 17 and 19 were only cited by counsel in seeking an extension. They did not go to the crux of the decision of the court. That a court analyzes a rule in obiter or a decision in obiter cannot or does not divest that court of the jurisdiction to hear the matter and come to a finding. My lords, nothing has been done by counsel for the appellants that the decision or the basis of the decision of the Court of Appeal was solely arrived at by a sub-rule that is not in legal notice number 114 of 2017, which are the proper rules. Indeed, paragraph 50 is instructive on this question. And my lord, we could even go to the second point. Under the rules, legal notice number 114 of 2017, and counsel should have told you this, which were enacted pursuant to Section 85A of the Elections Act. A record of appeal from the High Court to the Court of Appeal must be filed within 30 days. The only
Lady, is it only me? Have we lost?
We lost him.
Senior counsel, Professor Jiir, I think we've lost you.
I'm here. I'm here. I don't think I can be heard.
Now we can hear you, but we lost you for a second.
Yes, I'm back here. Your Lordship, I was submitting that under Rule 85 of Legal Notice number 114 of 2017, and only an extension of 7 days allowed to extend time. Were this court, therefore, my lords, be convinced, even for a minute, that the judges cited per incuriam wrong rules or draft rules in their judgment, in the body of their judgment, this court would be at a difficulty in curing the problem. My lord, we submit so because there is no compliant record of appeal that can give this court the jurisdiction to even hear the argumentation before you. None at all. Parties would still have to go to the Court of Appeal and extend time or purport to extend time, which time cannot be extended because this court has set out both in the Lemanken Aramat case that I argued before you and the Apungu Arthur Kibira case, that timelines set out in election matters is cast in stone. And therefore, there having been no proper notice of appeal filed in the Court of Appeal and not being on record as contemplated by Rule 8 of the Court of Appeal Election Rules 17, Legal Notice 114, my lords, there is no possibility that any bank sitting in the Court of Appeal can arrive at a different decision. My lords, I wish to conclude that this appeal has no legs. As this court found in the Nicholas Kiptoarap Korir Salat case, application number 16 of 2014, my lords, there is no possibility that an appeal can be filed in this court because of lack of jurisdiction. We apply that we strike out the records of appeal as filed and uphold the decision of the Court of Appeal, as the Court of Appeal correctly struck out the record of appeal in the Court of Appeal under both Rule 6 and Rule 8, there being no proper notice of appeal. My lords, I will allow learned friend Ombati to continue.
Mr. Ombati, you will have 7 minutes because we have compensated you with 4 minutes, which were interrupted.
Thank you, my lady, the Chief Justice and the President of the Supreme Court, judges of the court. I just will proceed from where my learned senior Professor Genda has left, and I would refer you to the petition of appeal that has been filed in this court. And my lord, it's instructive at what the appellant says at paragraph 22. They say, my lord, that the objection by the first and second respondent, which was supported by the third and fourth respondent, was on the basis that there was no valid appeal, as no notice of appeal had been filed by the petitioner. Then, my lord, they say, the petitioner referred the Court of Appeal to the notice of appeal filed on 10th of March and the receipt issued and the receipt of payment for costs. Although, this is important, it had been inadvertently omitted from the record of appeal. My lord, that notice that they say was omitted from the record of appeal is what they say is the compliant notice. The notice that appears as we speak now in the record of appeal at the Court of Appeal is at page 1563 and 1564 of the record of appeal, volume 1 or volume 11. And my lady, that record was filed in Garissa. Secondly, my lady, I would refer you to another instructive paragraph that has been dealt with has been pleaded by the petitioner. And my lady, that is an important paragraph because it lays the basis upon which the entire appeal fell. This is the petition of appeal at paragraph 79, page 37. This is what the appellant says, that the appellant shall urge that whereas this honorable court has pronounced itself severally on the extent of applicability of Article 1592D of the Constitution, this is what they say, the unique circumstances of the case before the Court of Appeal demanded that the learned judges of appeal exercise their discretion judiciously and allow the request by the appellant's advocate to file a supplementary record to introduce the notice of appeal as part of the record, having made a finding at paragraph 42. So there is an admission before this court that there was no notice of appeal in the Court of Appeal. And they say they ought to have allowed us to introduce a compliant notice. Out of time, my lord, that was 3 months after filing the first notice. And then, my lord, there is an impossible request or ask that has been put before you in the reliefs that are sought by the petitioner, and you'd find that at page 39 of the petition of appeal, paragraph 2A. They ask this honorable court to allow this appeal and reinstate the notice and the record of appeal in election appeal number 08 of 2023. The notice that they request you, my lady and the members of the court, to reinstate is that notice that appears at page 1563 and 1564. This is the notice that was filed in Garissa and not before the Court of Appeal. So, my lady, based on those requests, we will submit that it is an impossible ask that is put before you, and it cannot be granted. Now, my lady, the issue that was before the Court of Appeal was the interpretation of Rule 6 and Rule 8 of the Court of Appeal Election Petition Rules 2017. And that is the dispute. That is the dispute that happened in the Court of Appeal, and that is what has been brought before you. That is not a constitutional question. A similar issue, my lady, arose in this court in 2015 in the case of Ledama Olekina versus Samuel Tunai. That is our authority number 14 in the bundle. And the issue was whether costs, the sole issue of cost under Rule 36(1)(b) then of the election petition rules would constitute a ground of appeal before the Supreme Court. My lady, the Supreme Court said that an issue of cost alone will not trigger the jurisdiction of this court to determine a matter that is arising from the Court of Appeal. Now, before you is an issue about Rule 6 and Rule 8, fair and square, nothing more, nothing less. Our submission, therefore, my lord, is that there is no appeal that has been preferred that would trigger the jurisdiction of this court. And secondly, what you are asked to do is an impossible request, because, my lady, you are being told, validate for us the notice of appeal, which was filed in Garissa, and tell the Court of Appeal that this was a valid notice of appeal. My lady, that is not possible. And even if you were to return this matter to the Court of Appeal, they will still face the same challenge. What is the notice that appears in the Court of Appeal? It is the notice that was filed in Garissa. In simple terms, it is a plaint that was filed in the Chief Magistrate's Court, and then they come to the High Court and ask for an injunction. It is not possible. My lady, we pray that you dismiss this appeal on account of jurisdiction and on account of the prayers that are sought by the appellant. Thank you very much.
Thank you very much for abiding also with your time. We now move on to Mr. Mahat and your team for the third and fourth respondents.
Thank you, Madam CJ, Madam Deputy Chief Justice and Associate Justices of Supreme Court. It's indeed a great honor to appear before you. Madam CJ, for the third and the fourth respondent, we wish to state as follows. That number one, we have filed a response to the petition of appeal as well as the application. Number two, we have filed a replying affidavit sworn by the county returning officer. We have also filed our submissions which are on record, and we filed a list of authorities. The same have been filed and they have been served on all the parties. They are very comprehensive. We urge the court to look at them. They are able to dispense of this matter. That's the first point. Number two, Madam CJ, the position of the IEBC is that the appeal at the Court of Appeal was admitted on admission of the petitioners, the appellant in this case. And this is really interesting because the Court of Appeal asks certain questions to the petitioners in that matter. If you look at paragraph 22, which Mr. Omwanza referred to the petition of the appeal, it becomes very clear that there was an admission that there was no valid notice of appeal before the court. Madam CJ, if you look at paragraph 22, the petitioner states, the appellant in this matter, that it had inadvertently omitted from the record, and that is in reference to the notice of appeal. So they are admitting that there was no proper notice of appeal before the Court of Appeal. Madam CJ, I also want to refer the court to the ruling the court made. And at paragraph 35, Madam CJ, that is on page 17 and 18 of the ruling of the Court of Appeal. At page 18, the court stated that he further, that is the advocate for the petitioner, appellant in this case, he further conceded that the second notice of appeal filed on 10th March in the Court of Appeal does not form part of the record before the court. So the ruling, despite all the things that the petitioners want the court to believe, the ruling was made on the admission of the petitioners. And what the petitioners in this matter are trying to tell the Supreme Court is, we admitted that there was no valid notice of appeal at paragraph 35 of the ruling, at paragraph 22 of their current petition of appeal, even though we admitted that there was no valid notice of appeal before us. Kindly find that there was a valid notice of appeal before the Court of Appeal, admit it as properly filed, admit it as properly filed in the record, admit that the matter be heard. That is the first point. The second point that we want to make to the court, there's a lot of convolution about the issues that were in dispute in the Court of Appeal. The position of the IEBC is there was a dispute as to three issues of procedure. Three issues. The first issue was under Rule 6.1 of the Court of Appeal election rules was a notice of appeal filed in the High Court registry. That is the first. That is the first thing. And if you look at the rules, the rules on legal notice 114, Madam CJ, if you look at 6.1, and it's very clear that a person who desires to appeal to this court shall file a notice of appeal. So the court, the first Socratic deductive reasoning that the court underwent was there a valid notice of appeal before us? And on the admissions that I have taken you through, the court came to the finding there was no valid notice of appeal before the court. Then the court went into a secondary issue, and that is found in Regulation Rule 8.1, which states the issues the record of appeal should contain. And at 8.1i, it says shall contain a notice of appeal. And the court asked the second order question. You have admitted there's notice of appeal, there's no notice of appeal that you file proper before us. The second order question is that record proper? And the court came to the finding, since you made the admission there was no notice of appeal, then there cannot be record of appeal before the Court of Appeal. And the court made that second finding. Now, there's a third order finding the court made, and this is very interesting when you look at what the applicants want the court to do. The court, the issue was raised at the hearing, and since this was a jurisdictional issue, the court said, this is a jurisdictional issue, let me determine this, then the matter will be heard on merit. And the petitioners raised an issue in Rule 19.1, which says that a party has to file within 7 days if he wants to strike any pleadings from the record. And the court made the finding that is so, but when it comes to the issue of jurisdiction and when it is raised, then the issue of the court has only jurisdiction to determine whether they have a jurisdiction to hear that matter. And Madam CJ, we refer to the case, which is a persuasive authority of Ziad Abdullahi. E004 of 2022 is a Court of Appeal matter, which emanated from this WAJIR governor's petition. And the court, and at paragraph 27 of the said decision with Madam CJ, it's in our bundle of authorities. the Court of Appeal made the following finding as it relates to Rule 19.1. And the court said, it matters not that a PO was not filed within 7 days if it relates to jurisdiction. Such an objection, a PO on jurisdiction, can be raised at any time. And in fact, the court can raise it suo motu. And Madam CJ, our submission is at any time, even this court, Supreme Court, if a matter is before the Supreme Court, and the Supreme Court feels that it doesn't have jurisdiction to hear, and the parties have not in itself raised the issue of jurisdiction, suo motu, the court can tell the parties to address it on jurisdiction. So based on that, what have the petitioners done? And this is very interesting, because if you look at the petition of the appeal, the first page of the petition of appeal, Madam CJ, you will see the articles they are invoking to trigger the jurisdiction of this court under 163(4). They are invoking Article 27(1). They are invoking Article 48 and 50. 50, fair hearing. 48, access to justice. And equal protection, the equality under 27. And doing of this thing is in the pudding. If you read paragraph 27 of the petition of the appeal, those articles, number one, were not articles or issues that were at issue at the Court of Appeal. This is really important for this court, number one. Number two, the reason why those issues are being invoked at Article 51 is because the court listened to the jurisdictional question that was raised. And according to them, at Rule 19.1 bars the court from listening to any jurisdictional challenge, which is very absurd. If you look at the Martha Karua case, Madam CJ, which that court determined, the court is very clear. The court says the determination is unless an issue of jurisdiction is raised, and the court is very clear, when an issue of jurisdiction is raised, even under Article 50 and 48 that the parties are referring to, there are two issues that actually the court has to, there are bars to those articles. Number one is you have to be before the right forum. For example, a matter that is to be heard at the magistrate court you can't file in the Supreme Court. You have to be in the right forum. Number two, that forum must have the jurisdiction. So when these people appeared before the court of, the petitioners appeared before the Court of Appeal, the issue of jurisdiction arose. The court down its tools and determined the jurisdictional question. So to the extent that the Article 50 and 48 and 27 were not an issue before the Court of Appeal, to the extent that the court is entitled to determine a jurisdictional question when it is raised by any party, a party cannot claim his right of fair hearing has been infringed on because the court determined a jurisdictional question. Or a party cannot say he did not have an access to justice because the court determined a jurisdictional question which determined they didn't have a jurisdiction to hear that matter. The third issue we want to raise as it relates to this matter, we don't want to go through the rafts of authorities this court have determined in Anwar or Tip, in Samuel Kamau Macharia, about the issue of jurisdiction. When an issue of jurisdiction is raised, then the court is able to determine, and the court rightfully said so. Now that the issue of jurisdiction has been raised and the court determined, the second order question the court should ask, the Supreme Court, does that trigger the jurisdiction of this court as has been invoked? Our answer is the jurisdiction under 163(4) has not been properly invoked before this court. Because a finding of fact was made at the Supreme Court, whether a notice has been filed, it is on record that that finding has been admitted by the petitioners. It is a finding that that notice was not properly filed and the record is not properly on record. And even if this court was to remit back this petition of appeal, the Court of Appeal will come to the same finding because of the admission that is on record of the petitioners. Fourthly, Madam CJ, the third and the fourth respondents, unlike the first and the second respondent, face as a constitutional body would like to put to the court the following issues that might arise, the court making a finding that there's a valid notice of appeal before it. Number one, our first submission is that the decisions like this of public law, even though they originate in personam, once the Supreme Court makes a decision, those decisions are in rem and my client has to comply with it. That's number one. Number two, because a finding of fact has already been admitted, can this apex court revise that finding of fact as to the notice of appeal and the record of appeal that is not properly on record? Number three, if the court makes a finding that there is a proper notice of appeal for this matter, our humble submission is the court will be doing away with the requirement of notice of appeal for other matters in the Court of Appeal and amending Rule 6.1 and 8.1J as to that requirement. Number four, this will create as their decisis or presidential a precedent havoc, as there are other matters that my client is involved in, which the Court of Appeal has determined, and they are making their way through the appellate process. And some of them are pending judgment. Number four, Article 163 of the Constitution is a constitutional injunction against all other courts as relates to the decision that this court makes. That the decision made by the Supreme Court is binding to all other courts and tribunals in the Republic. Since the precedents of this court in Arwan, Ole Tip Tip, and many other matters have been to the extent that a notice of appeal in election petition is a mandatory requirement to trigger petition, the court should defer to its precedents. Even though we are aware the court is now bound by the decision it makes, it can change its mind. But for purposes of the matters going through the appellate process in this election cycle, the court should defer to its precedents, as that has provided stability within the electoral cycle. The court has guided my client and the lower courts as it relates to many of these issues. If you look at the totality of the pleadings, and even if the assumption that is being made that the court relied on an existing rules, which we say the decision at issue was Rule 6.1, 8.1J, and 19.1, which the court deliberated on, made a finding of. Even if this matter is remitted back, it suffers the same fate, because the court can view a finding that was made on admission of the petitioners. And Madam CJ, the petitioners know they are not without remedy. The petitioners had the option to certify this matter under the normal 163(4)B process. And 15B of the Supreme Court rules. They had the opportunity to show to the court that this was a matter of, that the decision made by the court was a matter of public importance and public interest, and the court will have had a deliberation on it. Since the issue that was before this Court of Appeal was not a constitutional issue, since the issue before the Court of Appeal was an issue that this court in Mataka case has even guided, that an issue of jurisdiction must be dealt with initially, since they exercise the jurisdiction under 163A, saying this is a constitutional matter, which is not, then this court must dismiss this matter with cost. The orders sought are not available to the petitioners. The court cannot make a finding on the regularity of a notice of appeal, because as I have demonstrated, the same was admitted and it's on record, and the court was not left with anything else on the basis of the admission of the petitioners. For those remarks, Madam CJ, thank you so much for listening to us and our submissions. Unless you have any question, or the members of the court have any question, we pray that the matter be dismissed with cost. Thank you.
Thank you very much, Counsel, for your submissions and also for observing time. Over to my colleagues on whether there is any question, please, with you before we return it to the petitioner for their response.
My Lady President, I don't have any questions.
Honorable Mr. Justice Renawa. I think he's having a problem with his screen. Justice Njoki?
No questions at this time. Thank you.
Okay. The Honorable Vice President?
Thank you, Judge President. Really, I shouldn't be asking any questions now, but a minor clarification, Judge President. Maybe the petitioner can tell us how they are computing 6 months? From which time?
Okay, so and the petitioner, you can also point us to the notice of appeal that was filed before the Court of Appeal, because you insist there was a variant notice of appeal that was filed in the Court of Appeal you could point it to us where it is in these records. I think we'll give you some 10 minutes to respond to the points of law that have arisen from the submissions by the respondents and from those two issues we have raised. The floor is yours, Mr. Omwansa.
No, my lady, it is Mr. Nyamodi.
Oh, Mr. Nyamondi with the senior counsel, Mr.
Kilukumi and Mansour. Yes, my lady.
Yes, sorry.
So, Your Ladyship, we had agreed on our side that learned senior counsel would deal with the reply, but maybe we can also just make a little time to deal with the two issues that have come from both yourself, Chief Justice, and the Deputy Chief Justice.
Please proceed.
Perhaps maybe, Your Ladyship, I can point out the issue of the notice of appeal.
Yes.
The notice of appeal filed in the Court of Appeal is found on page 4299 of the Record of Appeal. This is volume 30 of the Record of Appeal. Your Ladyship, together with the notice of appeal, may I proceed, Your Ladyship?
Yes, please.
Together with the notice of appeal, at page 4301 is the receipt generated by the court e-filing system for the notice of appeal, or for the filing of the notice of appeal. Your Ladyship, because of the way the e-filing system works, it is the e-filing system that generates case numbers. The case number is found on the top left-hand corner of the e-filing receipt, and it is COA EPA stroke E stroke 008 of 2023.
May I interject? I think counsel is referring to the wrong document.
Your Ladyship, perhaps senior counsel will allow me to make my point. I am answering a question from the court, and I believe it is my privilege to get it wrong. That is my answer. I insist it is the correct answer, and if senior counsel will allow me to complete my answer. Your Ladyship, that is a receipt.
Judge President, are you there?
Yes, I am.
Very good.
Yes, I think I got it, Mr. Nyamondi, the notice of appeal.
The notice?
I hand it, actually. It's only that it did not indicate where it was filed, the registry where it was filed. But now I got it. You see, it is a e-filing. Usually. Yes, I have got it.
Yes. And other than the notice of appeal, Your Ladyship, there is the deposit that is paid, and again, this is system generated. The receipt is 4302. It is auto-generated once you file the notice of appeal, and without filing the notice of appeal and paying the deposit, you cannot file the appeal in the e-filing system.
Thank you.
The second question, perhaps, Your Ladyship, is the question as to where we get the 1st of October as the limit or the outer limit of the Court of Appeal's jurisdiction or ability to deal with the appeal under Section 85A of the Elections Act. That comes from the fact, Chief Justice, members of the court, that the appeal is filed in the Court of Appeal on the 1st of April 2023. So 6 months from the 1st of April of October, I'm most obliged.
Your Lordship, may I comment on the response?
What was the issue? It was just clarification. I just wanted to be pointed where the notice of appeal is.
Yes, Madam Chief Justice, the council has misled the court, and it is important that we put
sorry,
the record
CJ,
straight.
I think it is good order for us to first listen to the response.
Yes.
I don't think council is correct to interject in the middle.
Your Ladyship, on behalf of the petitioner, it is our time to respond to the submissions made by the respondents. Your Ladyship, the Chief Justice, Mr. Nyamodi has drawn the court's attention to the notice of appeal, which was electronically filed on 20th of March 2023. This particular document was drawn to the attention of the Court of Appeal. And at paragraph 42 of the Court of Appeal ruling, the court acknowledged that this notice of appeal was filed in the Court of Appeal. And the only reason the court proceeded to strike out that notice of appeal was by applying Rule 6.3 of draft rules. According to the Court of Appeal, the notice of appeal, the Court of Appeal did not satisfy the requirements of Rule 6.3 of the draft rules. And that is what the petitioner is faulting the court in doing. Under Article 50, sub-article 1 of the Constitution, the court in resolving disputes is required to apply the law. It is not to apply either a bill pending in Parliament or a draft rule. And by the court applying the draft rules, then it made the conclusion that the notice of appeal filed in the Court of Appeal did not meet the requirements of the draft rules. That is what we are faulting the Court of Appeal for doing. Your Ladyship, the Chief Justice, members of the Supreme Court, it is important in our submission to appreciate we now have a hybrid system. Hybrid system in the sense that some documents will be physically filed and some documents will be physically filed. The physical record of appeal did not have the notice filed in the Court of Appeal. And that is the only admission that was made by the petitioner in the Court of Appeal, that the notice of appeal filed in the Court of Appeal is not in the physical record of appeal. We submit the court, having adopted e-filing, a document that has been filed electronically forms part of the record. And to confine record to physical records is to do an injustice. To accept an argument that records that are electronically filed are not in the record is arguments made in the 1970s, in the 1980s and 90s. In today's world and the way the court system is operating, I urge the court to take judicial notice that certain documents will be filed electronically, and once filed electronically, they will form part and parcel of the record of appeal. And if this argument was to be accepted by the court, it would then follow that the notice of appeal filed electronically in the Court of Appeal is a proper notice of appeal. And if the matter was to be remitted for hearing before the Court of Appeal, there will be a foundational basis, there will be a jurisdictional basis for remitting the matter back to the Court of Appeal. Your Ladyship, we want to clarify that the only admission made by the petitioners in the Court of Appeal and in our submissions before this court is that the notice of appeal electronically filed in the Court of Appeal was not included in the physical record of appeal. It is nonetheless our submission that a record that is electronically available to the court is part and parcel of the records kept by the court. We ask the court to allow the application by the petitioners and allow the petitioner to be heard on the merits of his appeal. If the court looks at the filed notice of appeal in the Court of Appeal, it complies with the gazetted Court of Appeal rules, the 2017 notice. But the Court of Appeal used a draft which had been released to facilitate public participation to invalidate the notice of appeal. If one looks at the notice of appeal, its contents and form, the court will the rules that were duly gazetted under the legal notice that has been referred to the court. For those reasons, we ask the court to allow the petition of appeal and to remit this matter back to the Court of Appeal for hearing. Parties had filed all the submissions, and if we were to be sent back to the Court of Appeal, it will be just a matter of days for the appeal to be heard and a decision rendered. We so pray that this appeal be allowed. Thank you, Madam Chief Justice, Deputy Chief Justice, and Justices of the Supreme Court for listening to us.
Thank you very much, Senior Counsel, for your submissions. I think this brings us to the close.
Madam Chief Justice.
Yes.
Yes, may I seek leave to comment on the response by learned counsel on the document because it misled the court. I think it's important that I just comment.
Okay.
Just 1 second, yes. Yes, Madam Chief Justice, the proper record, the proper notice that was filed appears at page 1563, and it was filed in the registry at Garissa. It is styled in the High Court of Kenya at Garissa. That is the proper notice of appeal.
No, that's your argument, Prof. That's your argument. There says that it's another one. So it's for us to decide now which one is the proper one.
May I just point the court to the...
Because you are regurgitating your arguments on the notice of appeal, which you are not convinced is the right one. So we are going back to the arguments. You'll just allow us now to decide for ourselves which is the right notice of appeal. We were just looking at a clarification.
It's okay.
Yeah, but still remains for us to decide which one it is, whether the one filed in Garissa or the one on page 43, I think page 40, the one I was pointed to, 4299.
No, this is a new one. It's a new one.
It's, yes, so we'll decide. So thank you very much, Council, all of you, for your submissions. We will consider them. We are aware of the very, very strict timeline that we have, but we will give our decision on notice. Allow us to consider the matter, and then we'll give a notice when we will give our opinion. Thank you very much for your cooperation. You all observed time, and wish you a good day.
On behalf of our colleagues, we thank you, Your Lordship.
Thank you.
Thank you so much, Madam Chief Justice and members of the court.
Thank you. Thank you. You may now leave the court.